Well, that's what I've been trying to get
No one
them to
dare
do.
say something to Ido.
No, I can do. I'm Ido's supervisor. I can tell you. I can
Okay.
supervise his to the tops.
You're the guy.
Well, it's a price that they pay for me having a policy of no name tags.
It's okay. It's okay. So I'm Yuval Shany. I'm from Hebrew University. I also am at the Israel Democracy Institute. Well, Elad used to work with him a while ago. And I'm also with the Human Rights Committee. So that was the back and forth before was about the Human Rights Committee, and I'm going to talk about. So actually, the former presentation dealt with targeted killings, which is something that is dealt with General Comment 36 of the Human Rights Committee that was issued in November, late October last year. The paper I'm going to present now. Can I start? Okay.
You're on.
So the paper I'm going to present focuses more on the interplay between counterterrorism, IHL, and General Comment 35, which is the preceding General Comment by the Human Rights Committee from 2014. So this is a paper I presented and then published. I presented it at a conference, at a workshop at Harvard that was organized by the U.S. Naval War College in collaboration with the Program on International Law and Armed Conflict, PILAC, and it was published last year, well, in 2017 in the International Law Studies, which is a publication dedicated to the laws of war, and they always say it's the oldest international law journal in the world, or in the galaxy, or something like this. So I'm going to discuss this, and I think I'll be happy to get your comments and thoughts, because not much has happened on this specific front since 2017, but we had this Minerva Center also has a sister center in Jerusalem, and we held in November, last November, we held a conference on detention policy. So a lot of the issues that are discussed here were critically also addressed there, and maybe we could go a little bit back and forth on some of these issues. So the paper basically takes the position that when the war on terror erupted in 2001 for the United States and for much of the world, I mean, in Israel we usually started in 2000, the year before, with the break of the Second Intifada, but essentially the various efforts or the various policies were somewhat merged. So the point is, and I'm focusing here mostly again like a lot on the UK, US, and Israel, because these are countries that we know well, and I think also much of the litigation action on detention policy in non-international armed conflicts happened there, at least the one which is visible to us. So when George W. Announced the global war on terror, this immediately played out into a question as to what to do with the detention policies. You remember after 9/11, the United States invaded Afghanistan and started detaining thousands of people, holding them in various facilities. Some were held in and around the battlefield, in Bagram and in other places in Afghanistan. Some were held on a transitional basis in what are called the black prisons, and all sort of informal detention facilities in different places around the world. Also, Macedonia was also one destination, but there were, of course, this is the Al-Masri case, but there were, of course, many others. Poland was involved, Thailand was involved, and other countries. And then, of course, the most famous of all was the detention, the Camp Delta, the detention facility in Guantanamo, which was opened very strategically, not only because there was already a naval base and a prison facility in Guantanamo. Those of you who remember the movie A Few Good Men remember that it was about Guantanamo, right? But this was the pre-9/11 Guantanamo. It was you remember this film? With Jack Nicholson and you cannot handle the truth, exactly. So it was already a frontier. It was like a frontier base already then. And Guantanamo, of course, was strategically selected as a detention facility for the long-term detainees, the ones the Americans thought they would have intelligence value, but also maybe they're in the long haul because of their complicity in 9/11 and subsequent hostilities. And the reason why Guantanamo was strategically selected was, of course, that it was designed to serve as what the UK House of Lords, Lord Stein subsequently referred to as the legal black hole. The place where the US Constitution doesn't apply. At least that was initially the belief of the US administration. This changed in Rasul, but it only changed in 2004. So originally the theory was that the US Constitution does not apply, and therefore there is no habeas corpus. So US law does not apply. But also international law does not apply, because under the understanding of the United States of the ICCPR, the International Covenant on Civil and Political Rights, which is the main civil rights treaty which the United States is party to, the applicability, this is something we discussed before a little bit, the applicability of the covenant only goes to individuals, covers individuals who are within the territory and subject to the jurisdiction of the state party. The United States and the Human Rights Committee has a long-standing standoff as to whether the two conditions are cumulative or alternative. The Human Rights Committee has taken the view that these are alternative conditions, and that the covenant protects individuals within the territory and also individuals within the jurisdiction. The United States and also Israel have taken traditionally the position that these two conditions need to be met cumulatively. And therefore, if the person is detained outside the territory of the United States, then the covenant does not apply. So it was strategically selected there. And of course, the second question, okay, so if human rights law does not apply and US constitutional law does not apply, surely IHL applies. Because IHL is the body of law that applies in armed conflict, and this was an armed conflict, and we know it was an armed conflict because the constitutional powers of the president, the war powers were invoked. The AUMF, the authorization to use military force, was passed following 9/11, and the United States did not contest that this is an armed conflict, but it did contest the nature of the conflict in question, and it did contest the applicability of the Geneva Conventions as a whole vis-a-vis detainees in that conflict, and the argument was that this is not an Article 2 conflict, an Article 2 Geneva conflict, because it is not a conflict between two high contracting parties, the war against Taliban and Al-Qaeda. And the Taliban is a little bit more complicated. Okay, Taliban, there were other arguments made initially vis-a-vis Taliban. When they lost power, there was also the Article 2 issues. And it was also not an Article 3 conflict initially, because under Article 3, a non-international armed conflict in the territory of the state party. So there is also a reference to the territory of the high contracting parties, which the United States understood to convey hostilities within its own territory. So the argument was Article 2 does not apply, Article 3 does not apply, and as a result, the end result is no body of law actually applies to this form of detention. And under this construction, it is either that the president has unlimited, unfettered discretion as to what to do with these individuals who were detained in times of war, or and I think gradually this position evolved is that, well, customary international law does apply, and customary international law in these areas is based on an analogy that is drawn from an international armed conflict. So if in an international armed conflict one can detain belligerents, enemy belligerents or enemy combatants for the duration of the hostilities, the same logic and the same maybe practice, to the extent that there is such practice, would point in the same direction. So this is what is called, I called in the paper, the hardline position. So the hardline position is that international law does not introduce limits on the ability of state parties to detain indefinitely suspects in terrorism in the context of an armed conflict. Okay, so this is the hardline position, and with some nuance, a similar position was argued here in Israel under the Unlawful Combatants Act from 2002, which took the position that individuals who are enemy combatants could be detained not indefinitely, but they could be detained for well, they could be detained indefinitely, and the detention would be reassessed every 6 months. But as long as they are as they create a security risk, and the 2002 does introduce a presumption that if they are members of an hostile force and the conflict is ongoing, then there is a presumption of a security risk. So as long as these conditions remain in place, then the detention, in theory, could go on indefinitely. So this is initially the hardline position. And what we have seen is that gradually, and this was a little bit stuff that Elad talked about, courts started pushing back, and courts started pushing back both in the U.S. and also in the UK, with more with regard to the Iraq detentions, but also with regard to the Afghanistan detentions, to try to basically introduce these detentions within a legal framework that is more human rights friendly by and large. And also here in Israel there has been a pushback, and I'll briefly explain what the pushback has been, and then I will try to evaluate what is the state of play currently with regard to the detention of suspects in international terrorism in the context of an armed conflict. So with regard to, let me go, So with regard to the United States, so I mentioned the Rasul versus Bush approach, which applied the U.S. Constitution to Guantanamo, and then came the first important habeas corpus case, which is Hamdi from 2004. Now, Hamdi is an exceptional case because this is a case which involved a U.S. citizen, someone who was detained in the U.S. So he was not detained in Guantanamo. He was detained in the U.S. and he was a U.S. citizen. And the question was there whether there is an authority to detain someone on the basis of the general war powers. And then the position taken by the court and the main decision is by Justice O'Connor, is that the AUMF provides the president with constitutional authority, with legal authority to exercise his constitutional powers, to take the necessary steps which are related to the conflict against the Taliban and its associated forces, Al-Qaeda and associated forces, and that this power, the exercise of power, namely detention of individuals for the duration of the conflict, and I now quote, is so fundamental and accepted an incident to war as to be an exercise of the necessary and appropriate force Congress has authorized the president to use. So the question is, has Congress passed on the president powers? There is a presumption that Congress didn't go beyond the four corners of the Constitution, but also beyond the four corners of international law. And the court says this is not beyond the four corners of international law, because international law, this is a fundamental principle. In times of hostilities, you may detain enemy combatants. Okay, so the court doesn't go into the nuances of this Article 2, Article 3. It basically reasserts the position that there is a general power of detention, but this is something that is already being reviewed. So this is a step forward. But then comes the Hamdan decision, and the Hamdan decision takes it another step further, because the Hamdan decision, which is a decision already in relation to a Guantanamo detainee, this is a 2006 decision, so this comes 2 years later. So there, Judge Stevens takes the position, rejects the administration's position about the notion that IHL does not regulate these types of detention, that the treaty law does not regulate, and he basically takes the view that it is either an Article 2. If it's not an Article 2, it's an Article 3. So the position is that at least, and I have to be careful here, the court doesn't explicitly say that the conflict in question is a non-international armed conflict for the purposes of the Geneva Convention, but it does convey that the safeguards that are provided to individuals under our common Article 3 of the Geneva Conventions, they would apply. Okay, it's not exactly clear to what extent did the court. So the court doesn't remove the power of the president to detain. It doesn't challenge the power of the president to detain. It merely rejects the position of the administration that the common Article 3 safeguards do not apply. So we are in a way moving towards a framework where now some IHL protections that mirror human rights protections start to apply here. So this is what happens in the United States. With regard to Israel, I will only note, in the interest of time, that the Supreme Court is hearing here in 2008 a challenge to the constitutionality of the Unlawful Combatants Act from 2002. And this is a challenge that it is brought on behalf of two Palestinian detainees from Gaza who are held in Israeli custody on the basis of information that they are members of Hezbollah. So the theory is, so the state says they are members of Hezbollah. Hezbollah is a hostile force. There is an armed conflict between Israel and Hezbollah. This is 2 years after the Second Lebanon War, which was a major round of hostilities. The threat of reinitiation of hostilities is still ongoing, allegedly. So this is the state's position. They challenge the decision to detain them, both on the facts, but more specifically on the whole legal framework, whether there is something like unlawful combatants. And the court takes a very narrow. Actually, the court rejects the constitutional challenge, but it adopts a very narrow interpretation of what the law is, and essentially states that it reads the decision as it reads the 2002 as simply another articulation of the pre-existing 1979 Act, Security Detention Act that Israel has, that allows for security detentions in cases the Minister of Defense reaches the conclusion that an individual generates a security risk for the public. So we do have this scheme. It roughly overlaps with Geneva 4, Article 42 and Article 78, scheme for detention, which is also a security internment regime. And the idea is that this unlawful combatants law would essentially produce the same type of regime, namely that it gives powers. This time it's to another official. It's the chief of staff who is the one who obtains detention powers under the act to designate individuals as security risks. And the court does, in a way, gloss over the difficult question of the presumption, whether by introducing a presumption of dangerousness, by the fact that someone is a member of an hostile force, the state has introduced a third category, a new category, either the combatants and civilians. And this was the whole discussion. Is unlawful combatants really a normative category, or is it a descriptive category of certain belligerents who do not enjoy, who have forfeited certain benefits? I'm not going to go into this hair splitting, but the point is, at the end of this decision, the court says the state has never actually invoked the presumption. The state, in practical terms, has always relied on specific evidence that tie the detained individuals to specific security risks. It showed that the individuals themselves were involved in activity which was harmful to state security. And the court says it is good that the state has not relied on the presumption. And had they relied on presumption, then we would have had to rule on the constitutionality of the presumption, hinting that it's not so clear how would the court come out on this. So in the end, we do have this structure where there is a body of law, but it gives the state relatively few additional powers to the ones it had before, which are, of course, I'll get to that momentarily, but essentially it's a 6-month review process. So you detain individuals, and every 6 months you have to produce information to the court that they are still they still constitute an individual risk, which prohibits their detention. Sorry. Well, they are detained indefinitely under the act, but every 6 months the decision has to be revisited. So you don't need to issue, like in administrative detention, you don't issue So but it's really a technicality. So you don't issue a new arrest warrant, detention warrant, but you review the existing detention warrant every 6 months. I'm not in practical terms. It does not make a huge difference. In practical terms, I should say Israel has not used this specific law very extensively. I think in the neighborhood of around 60 cases it had been invoked since 2002. Sorry?
Yeah.
So these are about the numbers, and also in terms of length, there have been all in all relatively few cases in which individuals were held for more than 2 years under all three detention regimes. There have been cases more, but there are very small minority of cases. There hasn't been a single individual who has been detained more than a decade. This is for sure. Okay, and this is so we have not reached a Guantanamo-like situation of individuals detained for now 18 years.
This is also with respect to administrative detention in the territories?
Sure. In all detention schemes. Yeah. So there have been very rare cases that go beyond 3-4 years. It's really, you can count it on the fingers maybe of two hands over the 40 years or so, 50 years in which it has been invoked. So Israel is using this, don't get me wrong, on the territories it is using this power on a massive scale. I mean, at any given moment in time, hundreds of people are detained in administrative detention. There have been times in which thousands have been detained. This is not the situation. Now we're talking about 300 to 400 people, which is a significant number, but the length of detention is relatively short, okay? So most of them are detained for a year and a half, up to 2 years. Okay, so this is the Israeli and the U.S. Movement away from the hardline position into a more rule of law scheme. I will note with regard to the UK has also engaged in security detentions in two different contexts. Both of them were designed in a way to introduce relatively few legal restrictions. So one scheme was within the UK itself, was the scheme of immigration detention that was applied after 9/11 vis-a-vis Al-Qaeda and affiliated forces suspects who the UK detained in the UK. Why is it an immigration framework? Because if the United Kingdom did not prosecute them, they would naturally deport them outside the United Kingdom. But there have been a number of individuals who were non-deportable because they came typically from countries who would have tortured them had they been deported to them. I mean, a country like Saudi Arabia would have been a place where sending back Al-Qaeda members could have created legal difficulties. So the United Kingdom has introduced legislation, the Anti-Terrorism Crime and Security Act from 2001, that allow those individuals to be detained in immigration detention until either they do not constitute a risk or there could be a place to which they could be deported. This scheme was, I would note that it was struck down by the UK House of Lords, as it was called then in 2004, in A versus UK, as being in violation of the Human Rights Act on basis of its unreasonable and disproportionate effect, also discriminatory vis-a-vis, because it only applied to foreigners, it didn't apply to UK citizens. So that was also a point which the court made. So this scheme was basically collapsed. It was then switched to a less harsh measure, which was control orders, which is also now not applicable in the UK. With regard to overseas detentions, the United Kingdom did apply initially Geneva Convention powers to detain individuals in Iraq during the first year after the invasion of Iraq, 2003-2004. This is something that here there was a question as to what to do with this from a human rights point of view. I'm a bit jumping the gun too soon maybe, but Hassan versus the UK is a case that did relate to that period, and it did arrive before the European Court of Human Rights, where the question was, can you detain someone under the Geneva Convention in a security detention if you did not derogate from the European Convention on Human Rights? Under the European Convention of Human Rights, the Article 5 detentions have to fit a very specific set of grounds which are mostly related to criminal process. Security detention is not one of the grounds which Article 5 of the European Convention allows. So what you normally are supposed to do in those conditions is to derogate from invoke the Article 15 derogation from the European Convention, and then you could can do away with the Article 5 limitations. The United Kingdom did not derogate from the European Convention, and that has to do with the question as to whether the European Convention applies in Iraq. Because had they derogated, this would have been in a way an acknowledgement that they accept the European Court. At that time, it was still controversial whether the European Court applies in Iraq, the European Convention, so they did not derogate. So this was in a way a bit of a vicious circle. You do not accept the power of the court, so you do not derogate, and therefore you put yourself in a deeper hole, legally speaking. And then in a very creative decision of the European Court of Human Rights, the Hassan case from 2014, the court basically said because they were operating, to make a long story short, the logic here, since they were operating within the framework of the laws of armed conflict, and the laws of armed conflict had equivalent human rights type protections to those found in Article 5, because the Third Geneva Convention and the Fourth Geneva Convention have many protections, due process and other protections for the conditions of detention, what have you. Then the court read in to Article 5 of the European Convention detention powers under the laws of war, essentially saying that the parties only intended Article 5 to apply in a context which does not involve detention on the basis of the laws of war, and read in the detention power. So in a way, it found the UK did not violate Hassan's right by the mere detention. Interesting. Okay, so this is a creative decision. It generated a lot of criticism, but the point is that you apply the laws of war, but that only, as I said, this only applied with regard to Article essentially Geneva 3 decisions in the first year, maybe also Geneva 4. But then came the question, what do you do subsequently with detentions after the first year, where there was no longer an occupation, and the UK was in a way involved in a non-international armed conflict because they were supporting the government of Iraq against the rebels, or supporting the government of Afghanistan against the rebels. So you were no longer within that area. So one approach that the UK tried to invoke for a power of security detention was to rely on the Security Council resolutions that authorized the international presence in both in Iraq and Afghanistan, and authorized these forces to take the necessary measures to restore peace and security in the countries in question. So the UK tried it, and initially UK courts did accept that Security Council resolutions such as 1546 from 2004 could actually trump the obligations of the United Kingdom on the of the European Convention, under the European Convention on Human Rights, by virtue of Article 103 of the UN Charter, so, which in a way gives resolutions of the Security Council a superior legal status over all other treaty obligations. But eventually the ECHR, the European Court of Human Rights, rejected this line of argument by saying that in order to invoke a Security Council resolution as grounds for deviating from a human rights treaty, you have to establish that the Security Council members explicitly wished the states in question to deviate, and that there is actually a presumption against such an interest by the Security Council. So this is like something that we know within constitutional law, the compatibility or conformity presumption. So there is a presumption that Security Council resolutions are compatible with human rights law and not contradictory to human rights law. So this was shot down as well. We do see now an attempt by the UK courts. This is Sirda Muhammad was mentioned before, to creatively work around this by taking the position that maybe the Security Council resolution could be introduced into Article 5 of the European Convention on Human Rights in the same way that the Geneva Conventions could be introduced into Article 5. So therefore there is no contradiction, because the Security Council resolution is now part. This is Al-Wahid case, so this is from 2017. So now the Security Council resolution is now read as part of the European Convention itself. So maybe there is no contradiction. We will see. The European Court would have to pass judgment on this. I have serious doubts whether this construction would fly. At the same time, the Sirda Muhammad case is a very interesting. So this was the first stage in litigation in Al-Wahid, Sirda Muhammad, and there this involved detention in Afghanistan. Al-Wahid dealt also with detention in Iraq. So this is a decision from 2015. But there, the interesting and what has put the whole field in some disarray is the position taken by the British Judge Leggett, that there is no right to detention under NIAC. So the position that was taken by the British Court of Appeal, that there is no right to detain individuals in a NIAC. So that's why you had to go to the Security Council resolution. So to make a long story short, where we are in terms of IHL, we are in a position where the war on terror is normally, to the extent that it is understood as a common Article 3 conflict, then we do have Geneva law kick in. And then you may have the question of if anyone is entitled to a POW status, then that person could be detained under the Third Geneva Convention for the duration of the hostilities. But if we are not within the Geneva, and there is not, of course, a single case in which a suspected terrorist received POW protection, although there is an interesting question whether a state can unilaterally confer POW status on individuals who are not otherwise entitled to POW status. This has been the practice of the US in the Vietnam War, where Viet Cong fighters did obtain POW status unilaterally. So that's an interesting question which raises issues which I may touch upon. But if we are outside this framework, we are either in an Article 2 conflict without POW status because a person doesn't meet the Geneva 3 Article 4 conditions, the uniform, the weapon, carrying weapons openly, membership in an organization belonging to a high contracting party, respect of the laws of war, what have you, then there is no explicit power to detain under IHL. There may be the Justice O'Connor approach that this is customary international law and that you can apply it by way of analogy. And when you get to NIAC, then at least the UK House of Lords Court of Appeal took the position that there is no power to detain under NIAC. Common Article 3 does not introduce a power to detain. It does introduce some standards that need to be preserved vis-a-vis the detained individual, but it does not introduce a power to detain. In international humanitarian law doctrine, this is somewhat controversial because the ICRC has taken the position that there is an implicit power to detain. Some states do subscribe to this idea that there is an implicit power to detain. As we have seen, this is not universally shared across experts. Whether you can rely on Security Council resolutions in some cases, perhaps. What, of course, you can also rely on is domestic law, because domestic law can create. So let me be clear. The UK Court of Appeal never said that IHL prohibits detention in an IAC. The question is whether there is a legal basis in IHL. Now, if you have a legal basis elsewhere in domestic law or in a Security Council resolution, maybe this is not a problem in terms of actually identifying a legal source, but we do have a question mark. What happens when domestic law? So it's unclear what happens when there is no ground for detention under domestic law, when there is no relevant Security Council resolution. And I'm reminding you about the disagreement as to how Security Council resolutions should be interpreted in this regard. Okay, so now let's talk about human rights law, because so far we have been discussing IHL and I've made some remarks about human rights law, but I think what I want to do now is to focus. How am I doing about in time with regard to time? We don't
have about 1 hour. There's no pressure on whatsoever.
Okay, so let's talk about human rights law. So far we have been talking about detention of suspected terrorists in connection with an armed conflict. Now, I've already alluded to the fact that there could be circumstances in which domestic law would be invoked. I mentioned Israeli domestic law as one example, both the security detention law from '79 and the 2002 unlawful combatants law. I've also mentioned the UK anti-terrorism law from 2001. In some respect, the AUMF is also domestic law, so there could be a basis in domestic law for detention, but of course domestic law in these contexts is of course is subject to human rights law. Like any other piece of domestic legislation would need to comply with human rights law. We've also seen the position of the European Court of Human Rights in Al-Jeddah that also Security Council resolution would have to be construed in human rights law. Now, what happens when you have an issue that is governed both by the laws of armed conflict and by human rights law? Here, all of us who work in the field know that there is this very famous advisory opinion of the ICJ from 1996, the nuclear weapons advisory opinion, which takes the very important position that in times of war, the applicability of human rights law does not cease. The ICCPR specifically continues to apply in times of war. However, the interpretation of human rights law would be heavily influenced by what the court called the lex specialis, which is IHL. So if you have on the specific issue of the power to detain, if you have within an IHL an authorization to detain, it is quite likely that under human rights law, the decision to detain an individual would not be regarded arbitrary detention for the purposes, now I invoke the ICCPR, the purposes of Article 9 of the ICCPR. Okay, so this is so that's why, in a way, it makes a huge difference as to whether you have a legal basis or you do not have a legal basis. Because if you do not have a legal basis, then from a human rights law, then that's a clear human rights violation. Okay, so this is one point which I wanted to make. Now. Okay, now with regard to Article 9, and Article 9 is now where I'm going to focus my attention more clearly, because Article 9, unlike the European Convention, Article 5 of the European Convention, which is has a closed list of grounds for detention, and it does not include security detention, and therefore I explained one has to derogate, invoke the war or national emergency situation and derogate in order to justify detention. Within Article 9 is more flexible, it is more open-ended, and it does have a general prohibition on arbitrary detention. And the Human Rights Committee, which is the UN body which is entrusted by the member state, well, it is the body, the committee of experts that is entrusted by the 172 states that have ratified the ICPR to provide authoritative interpretation of the ICPR, it did take the position that the Article 9, like with the following the ICJ advisory opinion, has to be read in light of the IHL, of the laws of war. And I'm going to quote now from the general comment, from General Comment 35. While rules of international humanitarian law may be relevant for the purposes of the interpretation of Article 9, both spheres of law are complementary, non-mutually exclusive. Security detention authorized and regulated by and complying with international humanitarian law in principle is not arbitrary. So the position here, there is parallel applicability. The fact that something is lawful, compatible with IHL, has normative implications under human rights law, but that doesn't mean that human rights law has no further relevance, because there could be elements, for instance, which are not regulated in IHL, and then we would have to fall back on the regulation by human rights law in order to address them. And there are also, of course, institutional implications, because if something is within the purview of Article 9, then the Human Rights Committee can monitor the application of Article 9 and read into it to the extent necessary IHL. Now, what I focus in this paper is specifically some of the grounds which General Comment 35 expounds upon. Let me try to find the text of General Comment 35. The most important. Okay. Let me read you the general comment, the relevant paragraph of the general comment, and then I will say a few what I think is where the general comment actually is relevant to our discussion of the Guantanamo detainees and more generally the war on terror detentions. But it was important for me to explain to you the framework for this paragraph, which is that we are talking now about the residual standards that are introduced by human rights law by the ICCPR. So I'm reading. This is paragraph 15 of the general comment. To the extent that state parties impose security detention, sometimes known as administrative detention or internment, not in contemplation of prosecution on a criminal charge, the committee considered that such detention presents severe risks of arbitrary detention, of deprivation of liberty. Such detention would normally amount to arbitrary detention, as other effective measures addressing the threat, including the criminal justice system, would be available. I will continue to read, but before that, I will make a comment that when the committee actually formulated this standard, there was very hot debate on the committee as to whether the committee should acknowledge, outside the situation of derogation, the very permissibility of security detention, where there were a number of members who took a strong position that security detention is always arbitrary, because you detain individuals not because of what they did, but because of what they are about to do. And this does not sit well with basic notions of criminal justice. At the same time, I think members were cognizant of the fact that there are a number of countries, including India and Pakistan and Singapore and Egypt and Israel and many other countries in the area, that do have security detention legislation. And I think there was also a question as to whether it is wise to encourage states in that situation to derogate. Because once you push a state to derogate, you in a way open up a Pandora box, because the derogation could be from Article 9, like Israel, by the way. Israel did derogate from Article 9 when it ratified the ICPR. But once you enter a derogation, you might derogate from other norms, including norms which are otherwise less flexible than Article 9. So the compromise text was that in general, arbitrary detention would in a way create a presumption of arbitrariness, but that presumption may be rebutted in circumstances which are analogous to a state of emergency. So I continue to read now. If under the most exceptional circumstances a present direct and imperative threat is invoked to justify the detention of persons considered to present such a threat, the burden of proof lies on the state parties to show that the individual poses such a threat and that it cannot be addressed by alternative measures, and that burden increases with the length of the detention. So you do have a possibility in extreme cases to resort to these measures in order to deprive, to facilitate the privations of liberty, provided that the risk is serious, and the longer the deprivation is, the more serious it is. I should note in passing that some countries like Germany do have what they call administrative detention or security detention, but for cases which have very little to do with this, soccer hooligans and who can be detained a few hours before a combustible soccer match. So these are really not the same kind of, but the notion of preventive deprivation of liberty exists in some other contexts as well. Now, I continue. States parties also need to show that detention does not last longer than absolutely necessary, that the overall length of possible detention is limited, and they fully respect the guarantees provided for by Article 9 in all cases. And then it proceeds: prompt and regular review by a court or other tribunal possessing the same attributes of independence and impartiality as the judiciary is a necessary guarantee for those conditions, as is access to independent legal advice, preferably selected by the detainee, and disclosure to the detainee of at least the essence of the evidence on which a decision is taken. So you have a minimum set of due process guarantees that is introduced to regulate these detention procedures. Now, why am I mentioning this? Because none of these guarantees are found within IHL. Okay, these guarantees are guarantees that you cannot find within the NIAC. Detention may be some humane treatment. You can read them into the notion of humane treatment, but the notion of specificity of judicial review. Well, there is something in Article 3 about review. Okay, regular
constituted courts.
Regular constituted tribunal, I think. Yeah. But many, let me retrace my step. Many of these standards are not found in IHL. And the question is whether, and probably the two most important one, which are very relevant to the Israeli situation, but also relevant, at least one of them, to the Guantanamo situation, is the question of overall length. So the committee takes the position that you can justify perhaps security internment, provided that it's not only that they do not last longer than necessary, which is obvious, but also that the overall length of possible detention is limited. So this is not an indefinite form of detention. I will revisit indefinite in a minute. The other thing, the essence of the evidence. This is also a critically important element. In the Israeli case study, you do have rather robust judicial review in the sense that every 6 months, every administrative detention goes before a judge, either a military judge or a civilian judge, depends on the various tracks. And both decisions are appealable before the Supreme Court of the State of Israel. So in a way, there is quite a robust routine legal review of the procedure, which also explains why the detention is not very long. But the problem in the Israeli case is that the evidence, which is the basis for detention, is by and large not disclosed to the detainee. So an administrative detention by and large is used when you have information on a person which you do not want to actually burn. So you have an intelligence source that told you that someone is involved in an act of terrorism. If you bring that intelligence source to a court of law, you burn the source, and you also and you jeopardize the source. Yes. So, or you expose the method by which you have obtained information. So if you have a wiretapping device, so this is why the information is concealed from the individual, and that raises serious fair play and due process concerns. So even the lawyer for the detainee cannot review the evidence. So in a way, what the court does, the court, with the consent of the detainee, reviews the evidence ex parte. But this is not those of us who are working on this do not believe that this is a fair and a proper legal process. And on the UK case, the question of the gist, how much evidence is going to be produced in control orders, this was essentially why control orders are no longer at use, because the UK courts require the authorities to provide the detainees or the person subject to control orders with the gist of the evidence against them, so as to make it. So it's very important that this element is within. Now let's go back to the issue of indefinite detention. The issue of indefinite detention is important here, both because of proportionality concerns, but also because of a specific concern about the mental suffering associated with indefinite detention. There is a very big difference between telling someone you are going to sit 3-4 years in prison and telling a person that you are going to sit in prison until we release you, until we decide to release you. So this is, and there is some movement within human rights bodies to qualify indefinite detention as cruel, inhuman, and degrading treatment or punishment because of this element of uncertainty. So even if empirically these detentions are shorter in Israel, in the UK, in the US, by the way, they are not shorter. They are already. We are talking about the first Guantanamo detainees started to arrive late 2001. So we're talking about 17 years of detention, which is already in some cases probably more than they would. Some of them would have gotten in a court. But the element of uncertainty it was identified by the Human Rights Committee as a particularly serious issue. So what does all of this tell us? If the power of detention is not grounded in IHL, but rather in domestic law, then the power of detention has, like any governmental power, has to be exercised in accordance with human rights standards, subject to derogations. Okay, these elements, because they are configured within a framework which mirrors the derogation framework, it is quite unlikely that the Human Rights Committee would regard these standards as derogable. And actually, the paragraph on derogation, which the general comment has, does allude to the fact that maybe in international armed conflict you can derogate because the Geneva 3 and 4 do have comparable safeguards, with the exception of the overall length of detention, where there is no comparable safeguard. With regard to IAC, there is a stronger presumption that the paragraph 15 standards would apply. So even if there is a power to detain under IAC, it is so thinly regulated that the lex specialis rule would not kick in here to displace human rights law. So in a way, it's a little bit of a equilibrium where you have in IAC, where you have a rather detailed regime. It is more plausible to claim that human rights law takes a back seat than in NIAC, which is in the majority of counterterrorism detention cases, where it is not going to take a back seat. Now, if you are applying detention within an IHL framework or within a Security Council authorization framework, now I would argue that the Al-Jeddah holding is that you need to interpret IHL in accordance with human rights obligations. So in a way, although IHL is lex specialis, although I should say the Human Rights Committee never uses the term lex specialis. They don't like the term because it doesn't denote a certain hierarchy, and it also, some states have a very, like Israel, have a very romantic, not romantic, they have a very expansive understanding of lex specialis. They think that if there is lex specialis, so the whole human rights disappears, so it's only one regime. So this is certainly not the idea. The idea of even of the ICJ was that some norms would in a way it's an interpretive dominance. But even under that construction, you still, when there are areas in IHL which are not articulated, for instance, torture is not explained in IHL, what torture constitutes, or what is fair trial, you do read in human rights standards, so that would also kick in here. I think the one area where I would concede that we do have a direct clash, and on this I don't have a good answer, is what to do with the POW issue. And here I just want to I'll make two observations, and with that I will stop. Now the reason why we have never thought about the problem. So the POW issue is such: under the Third Geneva Convention, it is uncontested that one can detain individuals as POWs for the duration of the conflict. Okay, there are provisions, I should say, about the parole sending. There is some encouragement to release POWs on their parole, that they would not return to the theater of hostilities. There is also a specific regulation of sick individuals who are ill and would be 1 year out of the. But the reason why we do not, it's not very surprising that we don't have a time cap on Geneva 3 POW detention, is that up until 1949, maybe with the possible exception of the 100 years war between the UK, England and France, wars were relatively short. So modern conflict normally didn't last decades and decades and decades. Armed hostilities. Yali is not convinced, but we will hear. So the idea was, this is, first, it is short based. Secondly, it's based on reciprocity. So you have prisoners of the other side, and you organize, if it gets too long, you organize what are called the cartels, the prisoners exchange. So practically speaking, there were not many, it was not a widespread phenomena that POWs were lingering in prisons for decades and decades and decades. Now, with regard to NIAC, it's of course very different, because these are essentially the long wars, never-ending conflicts, no reciprocity. So here it's not sure how it actually plays out, and it's interesting that in the decision which I mentioned before, Hamdi, where Justice O'Connor actually held that by way of analogy, you can read powers of detention from IAC into what we now understand is NIAC. She introduced the following language, and this is the language that we use. If the particular circumstances of a given conflict are entirely unlike those of a conflict that inform the development of the laws of war, that understanding, that we can simply borrow by an analogy, may unravel. But that is not the situation we face of this date, 2004, 3 years after 9/11. So I'm arguing that this is actually the situation that we are witnessing at this date. So 17 years after 9/11, I think we are seeing something that we have not seen before, certainly not on a widespread system. So the whole idea of, so we do have here, maybe this is something that cannot be fixed by interpretation, but we do have here a problem with Geneva 3 to the extension that Geneva 3 is directly applicable. Now, if Geneva 3, even if Geneva 3 is applicable, then there is the question of what do you do if you take seriously the argument that indefinite detention, essentially for life, is cruel, inhuman, and degrading treatment. And this is a claim actually that is being made now outside the armed conflict context with relation to life without parole sentences, where there is a claim which has already been discussed by the European Court of Human Rights in a case called Winter versus the United Kingdom, that such a punishment without a realistic possibility of obtaining parole at some point, with having the decision reviewed and reconsidered, this could amount to inhuman or degrading treatment or punishment. The Human Rights Committee has taken a similar position 3 years ago in a case involving Australia. I should say that specific case involved minors, individuals who were minors at the time of the offense, and for them it was easier for the committee to incarcerate minors who've committed a horrible, horrible crime. but to incarcerate them for life without parole for a crime they committed as minors would be cruel, inhuman, degrading treatment or punishment. But if we take the same approach and say that to detain someone for life, for basically detain him for the rest of his life, or with the possibility that he would be detained for the rest of his life, and his freedom would depend on circumstances that are outside his control. And this is different from the criminal suspect, where the question of rehabilitation and reintegration in society is to some extent within the control of the individual in question. Here it is not so. If we are talking about a Geneva 3 POW system, then it is outside the control of the individual in question. Then there is a question of what do you do when you have two norms, and when one norm is claiming to be a jus cogens norm. So if the prohibition against torture, cruel, inhuman, and degrading treatment and punishment is a jus cogens norm, and we have significant authority for that proposition. Probably the most forceful articulation is the ICTY decision for Rungia from 1999 and 1997 on this. Then this could be a situation where, although IHL is the lex specialis, the human rights law would be the lex superiori on this. I think I'll stop now.
Okay, so let's collect some questions and let you breathe for a while, and then.
Sure.
Yeah, anything? Who wants to say? Just
Yali wanted to dispute.
Manu? And you've said several times it haven't been a while, so every time I turn to my historian.
You almost said unprecedented at one point, so
I
looked
turn
at
to the
him.
historian
Okay.
every time. Elad, and then the second run, Ziv will be start. So Yali.
Thanks, Yuval. It's really interesting, and just maybe 2 points. First, I remember when I read your paper, I thought, well, this argument is being made frequently about the never-ending wars, and I wasn't sure that it's the case. And I thought about conducting an empirical study, because if you think about the Iraq-Iran war, about the 30 Years' War, the 100 Years' War, the World War II, these were long conflicts, and we know that non-international armed conflicts can be short. And well, ISIS was defeated relatively quickly. And maybe instead of looking at the war on terror as the ultimate example of indefinite war, we can just say, well, we have currently no armed conflict with Al-Qaeda, or at least in some respects. So to criticize the classification of the US, rather than thinking that the nature of NIAC as such is something that will, because in a way it legitimizes this notion of indefinite armed conflict, and I think that it's in most NIACs we can pretty easily determine at some point at least that there's no armed conflict at all, and I'm sure that there's a long list of NIACs that are relatively short. The second is question regards the relationship between General Comment 35 and 36, or more specifically, whether what is the justification for a different position regarding status-based targeting and status-based detention? Right. So, if we think that the ICRC DPH study or the Israeli position about formal membership approach, or the US position, or international armed conflicts position regarding targeting legitimate, we can see it as lex specialis. What justifies this position in contrast to detention, where something unique about individual threat, the need for individual threat. And relatedly, I think that POW, we have a different problem with POWs, which is detention without individual threat. So I think that if we would have, if you take a position that right indefinite detention or detention until the end of hostilities is something extremely problematic, even when we think about POW, I would think that detaining the military cook until the end of hostilities is extremely problematic from the human rights point of view.
But the other prisoners in the camp would enjoy it.
Yes.
Correct.
As you wish.
Danny?
Yes, thank you for your talk and the article. I don't have enough knowledge to go into the content too much, but to put it more into my framework of understanding, I wanted to ask you how to place or where to place the Tammy case in the Israeli detention framework. Was she considered an enemy of the state by attacking a soldier? And is there a difference in the territories of Israel between detention of minors and adults?
I can take this just 1 second. Tamimi is not an administrative detention case. It's a criminal law case. So she was charged with a criminal offense, and she was prosecuted, and she struck.
About what is the Tamimi case?
The Tamimi case is this Palestinian teenager that hit a soldier who was basically standing in her yard, and they filmed it, so it was a bit of a story that was part. I'm not going to be judgmental about it, but there was it created a lot of stir here and around the world, and she was prosecuted for assaulting the soldier, and she after. The controversy in the Tamimi case was why was she detained for until she was detained during the criminal proceedings, which is highly exceptional in cases involving minors. In Israel, it's almost unheard of a minor who's not committed, who's not murdered or something, that he or she would be detained while the trial is ongoing. And it was clear here that the military felt. Clear is a strong word, but many observers thought that the military was humiliated, or the politicians were humiliated, and therefore there was a harsh response. But it's a different framework whatsoever, and in the end they struck a plea bargain. She served 8 months, and she's back home now.
Thank you for this very, very interesting talk. One of your highlights was to say that we take a problem that IHL is not addresses well, like the duration of hostilities in the terrorism context, and then use human rights framework to sort out this ambiguity. What's your point on another problem with IHL detention in this context, in the terrorism context, as not to the time dimension but geographical dimension? The fact that states, and specifically the United States, expanded the battlefield to everywhere, and then use IHL detention even if they detain someone in Libya or Somalia or other places, and then relate everything to that conflict that originated from Afghanistan. So I was wondering, what is the human rights perspective on that, and if you think it's appropriate to use human rights law to fill some gaps that IHL has in this context. And one more question. You did talk about, in the human rights law context, about the problem that we use to detain people. We use secret evidence, or evidence that cannot be disclosed completely with the detainee. And in practice, I think it's a huge problem, because there are good reasons for the state to keep this information undisclosed. But of course, it creates a due process problem. And there are different solutions to that. The UK system uses the special advocate system. In Israel, we see a lot of the burden on the judge in the case that should be the mouth to the detainee. And I was wondering if you have any position about the propriety of those solutions.
Okay, so length. Yali says some na'iks are short. Of course, some na'iks are short, but I think some na'iks are very long, and it's. I think experience shows that na'iks. We have seen in recent years a number of very long na'iks Colombia actually is another good case, since where you had almost a 40-year NIAC. 50? And it's not accidental. It's because it has to do with the level of violence. It has to do with the fact that this is often has a domestic dimension, which is very hard to resolve. It's an interesting question, and I didn't do maybe Ziv has the answer, where in terms of what was the mindset of the drafters of 1907, 1949 regarding duration. My guess is, at least from what we learn about occupation, and you look at the Fourth Geneva Convention and Article 6, the 1-year cutoff, there was a general, I think maybe naive. It also has to do with the UN being in the picture to resolve things. I think there was, my sense is there was a perception that conflicts, even the conflict you mentioned, World War II, 6 years, Iran, Iraq, 8 years. There was a perception, of course this is later, there was a perception that wars are relatively modern wars. We're not talking about the 30-year war, the 100 years pre 19th century, because of technology, because of the devastation. I mean, long wars would simply be untenable. But I haven't done the empirical work, and I'm not sure I'm going to do the empirical work. This is a work for historians, and I'm not sure it really changes much my normative argument, because even if they had this perception or that perception at this point in time, it's obviously wrong to detain someone for 30 years. So even if the drafter thought it was a good idea to detain, I would still challenge them. You are right on the AUMF, and I do argue here that I also make the point, the subtle point, that relying in 2017 or 18 or 19 on the AUMF to detain ISIS members, when the whole thing started with Al-Qaeda, this is a very significant expansion of the framework. Obama made a speech 4 or 5 years ago, basically saying that the conflict in Afghanistan is winding down, the war on terror is winding down, and there have been no follow-ups. So this is another avenue, and I predict here that at some point in time, the U.S. courts would review the constitutionality of relying on the AUMF. So far, it has not happened, but I think you are right. It's there is this element can be criticized, but there would be some
They
NIACs.
specifically dismissed the case on that. The
Sorry?
Smith case, in the DC circuit, they specifically dismissed the challenge to the application of the AMF to ISIS.
Yeah, but well, the DC circuit dismisses all cases,
Yeah,
national
it's true.
security cases. So that's why it is. They're elevated to the Supreme Court from the DC circuit. I've lost my train of thoughts, but on the AUMF. Okay, so that's what I think I wanted to say, that you're right. No, I wanted to say that there could be some cases where there is like Colombia, there could be cases where there is undoubtedly a 40, 50 years conflict. Okay, and maybe the conflicts that we are experiencing here are also very lengthy conflicts. And you could argue on Hezbollah where there is still but even if states are wrong, you still need the normative, you still need to get the normative proposition, and it may even push states not to be too greedy about expanding, because they know that at some point their powers to detain expire. It may give them pause before they just extend these conflicts indefinitely. It's a little bit the same with the global battlefield. I will return to your second point, but the global battlefield, it's from the human rights analysis is very much tied to the IHL analysis. If the IHL analysis accepts the global battlefield theory, and as you know, this is something which is contested within IHL. It's not clear cut, of course. There could be. World War II, of course, was a global battlefield, and there could be circumstances where a conflict is orchestrated from the territory. But when you combine You have a very broad
Muslim
geographical
enemy.
dispersion, and you have very different groups, Boko Haram and the Shabab in Somalia, and ISIS and Al-Qaeda, and at some point in time, I mean, these claims lose their credibility. So here I think the combination of time, organizational spread, and geographical spread is such that is making these cases very dubious from an IHL point of view, and thus also from a human rights point of view, because if you do not have an IHL authority to kill individuals, it's arbitrary killing. And if you don't have an IHL authority to detain individuals, it's arbitrary detentions. So the issues here are linked. The status question, what is the difference between status-based? So first, of course, Geneva 3 is status-based. I mean, we were talking about Geneva 3 as in a way being anomalous. The question is whether targeting is status-based or membership-based. I thought that I thought the ICRC got it wrong in the interpretive guidance, the 2010 interpretive guidance. I thought it would, and I thought the Israeli court got it right in targeted killing in the sense that it is not membership-based, but it's rather risk-based, and that you have to show, and I think this creates, on targeting, and this would have created a good equilibrium also in terms, this wouldn't actually created much gaps. When you move in that direction in regard to targeting, then you do have to justify why aren't you applying the same standards. The Israelis try to do this with the unlawful combatants law. I think it's a bit more complicated because I think there could be two arguments that are made. First, you do have within the detention area, you do have a more rich set of tools. So you do have also criminal law, and criminal law in Europe is much is membership based. So and being a member of a terrorist group is an individual responsibility offense, but which is essentially membership based. So when you throw in criminal law into the picture, the gap is much narrower than what you have before. Secondly, I think the idea of targeting on membership based is based on an epistemic issue, which is it's very difficult to identify risk from high up in the air or from a sniper's. You're seeing, if you see an individual with an enemy uniform, it's very hard for you to know whether he's the cook or whether he's the rocket guy. So this is why you have a broad sweeping rule, and you could argue whether that sweeping rule should apply when you know that he's only the cook, but at least this is your point of departure. When you have the individual in custody, you have the possibility to actually ask all these questions, so you could know whether they're the cook. The epistemic challenge is much lower. But as I said, I think I disagree also with membership based in targeting in IAC. So I guess at least I'm consistent. On the issue of the evidence, so on Tamimi we discussed Tamimi. On the issue of evidence. I'm in favor of the special advocates model. I think the special advocates model is not ideal, but it's the lesser evil, and that is the system where you have a lawyer actually reviewing the evidence, not representing the detainee, but representing the interest in not detaining the detainee unnecessarily before the court. So you have so this is. I mean, I actually in my idea, Israel Democracy Institute we were trying to work actually with members of Knesset across the aisle, from Smotrich to members from Meretz, extreme right to deep left, and basically get them to sign on law which actually introduces this special advocate system. Of course, the extreme right is open to discussion on administrative detentions, because some extreme right activists are also subject. Some Jewish extreme right activists are also subject to administrative detention. The numbers are, of course, much smaller, but they are occasionally detained, and so there is more openness to deal with these issues. So I think this is a good. This is for us a better model than the existing one. And I think the main importance of having a special advocate is that the special advocate, so the process that we have envisioned and we are trying to sell to the government essentially is that there would be two stages in the process. The first, in which the special advocate would challenge before the court the decision not to provide a more substantive gist, not a thicker gist to the detainee and his attorney, try to basically declassify as much evidence as possible, and only after this fails or after this, if needed, he or she would argue for the detention. So this could have also a positive outcome in terms of releasing more information on the reasons for detention, giving the detainee more material to work with. This so far has been resisted by there is within Ministry of Justice there is openness for this, but and even the president of the military courts in the West Bank is supportive of this because he doesn't want to be in that position as well. But the Israeli Security Authority, the Secret Service, who is compiling these files, they are very concerned about information leaks. So it appears that they so far have put the brakes on this.
Even if the special advocate is a military lawyer, in essence?
Even if the special...
What your model suggests? Civilian lawyers,
it will be someone who has security clearance, ideally someone who has worked on the military side in the past. But we didn't foreclose the door from someone who has worked on the detainee side before. But he or she must have security clearance, that's for sure. They are concerned about leaks because more people will review the information, so it's expanding the circle. And it's also going to be more, the process is going to be more lengthy, more cumbersome, so there's also a concern about the costs this would have for the whole system. And maybe they will lose more cases.
Maybe.
So, first of all, thank you. Actually, regarding an historical comment, there are two elements in going back in history that actually support your argument. And first is the idea of parole. Once parole has been expanded from nobility to all soldiers, the idea was to make that distinction between personal risk and the security concern from the person's nation. Because if the person is released under certainty that that person will not return to fighting, so the personal risk does not exist. So the argument would say once the mechanism that has existed within IHL has gone into dysfunction or disuse, there need to be this compensation through modern mechanisms that exist in human rights law.
Okay.
Another element, historical element that does that gives some support to your perspective is the fact that the first war in which there is serious discussions of the issue of POW conditions is the Napoleonic War, or what's more accurately should be called the French Wars, which go from 1793 to 1816. And Napoleon intentionally refuses to sign cartels and refuses to release soldiers on parole. And then you start to see the serious discussions regarding POW conditions. So again, extended wars do raise these issues.
Okay.
Thank you,
Great.
thanks Yuval. That was fascinating gallop through the past 15 years. Lots of bad flashbacks occasionally as I was dealing with some of these issues in my previous life with authorities in Iraq. Just pour la petite histoire, I remember being in Iraq discussing with the British and Americans, well, the Americans and the British, whether they thought human rights law applied, and I'd put the same set of questions to them and then say, so do you think human rights law applies? And the US would fall off its chair saying, how could it possibly? And then I remember flying down to Basra, having the same conversation with the Brits. Do you think human rights law apply? And them falling off their chair, how could it possibly not? So that's within the same coalition. Lots of questions. In a way, we're dealing with the fallout of past conflicts, and I'd like to hope that there's a lot of acquis, that states have accepted a lot of what has been laid out by various bodies now, and I'm just wondering, where do you think the real line of battle is at the moment in relation to these issues? And I wonder whether we have adequately addressed the procedural safeguards dimensions to it. I think that's probably still unsettled, and something that I was coming up in my work is when I was in Iraq and trying to draw analogies to Israel, saying, look, let's look at what they've done in terms of procedural safeguards. The answer I often get is yes, that they've got a handful of people, we've got several thousands on our hands. So what is feasible in situations where there is an ongoing conflict and you do have a number of people held under internment? And then I didn't quite understand how human rights would require us to deal with indefinite detention. Would it require setting a fixed maximum, saying, and in any event it wouldn't be more than X years? That would be it. And then, interestingly, I was looking, again, being very practical, I was thinking, well, how could we deal with POWs? Could we get, and this is in fact what was happening ultimately in Iraq, that there would be some kind of parole system, some system of conditional release whereby they committed to not returning to the battle, because really that's what it's about, isn't it? It's about making sure POWs don't return. So could we envisage some kind of system that would assure that?
There was this argument, but then the states said that parole is our right and not the individual soldier's right.
Yes.
And
yes.
that's what led the parole system to disappear.
But I also
with the protecting powers.
I also think that it is not necessarily in the interest of the detaining state to have a significant number of people on their hands that they need to pay for prolonged periods of times.
So thank you. Thank you, Uzi, for this comment. The Napoleonic Wars. Okay, interesting. I have to look at it. Anyway, the POW convention is more than a century later, but I was thinking more of the 20th century, late 19th century conflict. But yeah, the Napoleonic Wars could be interesting, and they're really the point in time where you move to a people's army. So it's maybe. Here it's where the first time there is this dissonance between the laws, and because of course in the Middle Ages, yes, I mean you would have detained individuals or sold them to slaves until someone was ready to, but that was a very different system. The issue about risk is also interesting, and I think this is a strong point that you do have in Geneva 3. You do have the notion that when someone is ill, or when someone undertakes not to return. Then you have to release that person. Well, you may release them if they. So I think so that's an interesting argument which I could develop. Where's the fault line? So the fault line is, I think, on the exactly on the issue of power to detain. I think this is where the big issue still is out there. The ICRC is pushing very strongly. I haven't seen the ICRC, I must say, before pushing so aggressively a normative proposition, which is not clear as to how it plays out in terms of what's the more humanitarian point of view. I mean, it's quite interesting, but they think it's I think they mostly want to fend off human rights law. There's a strong sense that they would rather introduce these standards and have the Geneva committees that don't know anything about laws of war, etc. Handle these issues. That is my sense that this is part. They were very unhappy also with General Comment 35, with the fact that we, the Human Rights Committee, have intruded into their turf. I didn't mention the Copenhagen process, which is another interesting process, but the Copenhagen process is a process, an interstate process which tried to develop standards, but interestingly enough, it glossed over the question of whether there is power to detain or not. It basically said that assuming there is power, these standards have to be complied with. I'm not sure I got your who had more detainees, the Israelis or the Iraqis?
The Iraqis in Iraq. There were
okay.
Tens of thousands at some point, most of them as security internees, and you had to propose a process that was feasible with that many people in your hands.
So my anecdote in this that I filed an amicus in Boumediene, which is one of the U.S. Supreme Court cases on the standards of detention in Guantanamo, and the question in Boumediene was: is the United States required to introduce periodic reviews of detainees? Not only initially the system was there is a review only upon detention. But there is no periodic review as to whether they still constitute a risk, and the argument was by the U.S. authorities that they cannot handle the workload of doing periodic reviews for the Guantanamo detainees. And our amicus, I mean, the main point that this is a ridiculous argument because they had at the time 200 or so people in Guantanamo. And Israel was doing for thousands of people at certain points in time. They were doing these periodic reviews. So for the U.S. to claim that they do not have the resources to do any periodic review for a small particle of the numbers. So again, not that Israel is a model in these issues, but at least it is for better or worse, it has brought these cases within a rule of law, which they eventually the U.S. Supreme Court accepted in Boumediene the crux of this position, and subsequently there is a periodic review put into place. What was the other point, Manu? I have here unintelligible.
Handwriting. A question or handwriting?
No, a question. I can't understand. I can't understand my handwriting. So
Oh, so it's unintelligible handwriting.
No, my notes are unintelligible.
It's about General Comment 36 and what you ended up doing with. I'm joking. That's another question I have.
Right.
So this is the right to life general comment, and it strikes me that.
No, but what was the question I did?
can't remember which one you haven't
Okay.
answered now. So
So
I think you've answered most of my where the fault lines, and you say it's the entitlement.
whether it's a fixed period. So
And you've answered that to me.
yeah. So I think it has to be a fixed period in advance. I mean, here when we were discussing this with government, we were talking about 2 years as the
Wow.
ultimate. Now this doesn't mean that after 2 years you cannot start the whole thing again if this is not abusive. So you release that person, and if you have new information that person is still involved and still continues
You have 30 seconds outside now.
Yeah.
Now you're under arrest again.
Isn't that worse?
No. I said it's not abuse. That if you have, so it's like an. Sorry.
Like under delay in the proceedings, where you can have fixed for the length of the trial.
Why? How is it the same?
No. I'm saying it has been done in other contexts.